Ma'am, are you Veronica Sanders? And before we start, I'm going to take judicial notice of the court's file. It includes an evaluation for competency that Dr. Prapon prepared for us, dated September 17th of 2023. The finding in that report was that Ms. Sanders is currently competent to stand trial. Is there any other evidence with regard to competency, Mr. Rojas?
There you are.
Mr. Nichols. All right, then at this time I am going to find that Ms. Sanders is competent to stand trial. And Mr. Rojas, what is the announcement?
Judge, I speak with Ms. Sanders, and she has decided to plead not guilty in these cases and set up for trial. However, she did not want to sign the tablet today.
Okay. So, Ms. Sanders, in cause number 23, DCCR 1005, you're charged with the second-degree felony offense of burglary of a habitation from July 19th of 2023. And what that means is if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 20 years in prison. Do you understand? And then in cause number 23, DCCR 1114, you're charged with the second-degree felony offense of assault on a peace officer from July 18th of 2023. That indictment alleges that you were previously convicted of assault on a public servant, March 24th of 2021. And what that means in that case, and probably in the other if the state gives notice of that correctly, is that you would be looking at a first-degree felony punishment instead of a second degree because of that prior offense, which means the minimum punishment would be 5 years up to 99 years or life. Do you understand that? Do you have a question?
Yes, ma'am. Like I said, that's why I'm taking. I'm a little nervous. Excuse me. That's why I'm taking the trial because I had seen the video. I had seen the video yesterday, and then the video don't shows where I beat the police officer. So that's
all right. So here's the thing. So hang on. So just you've talked to Mr. Rojas. I don't want to get into the actual evidence or you talking about the case today on the record. But let me just explain, and I'm sure Mr. Rojas has explained this. What will happen in a trial is the police officer himself or herself will come and testify. Whether something, and then if there's a video, they'll show that video. And then if you say you didn't do it, then it'll be up to the jury to decide if they believe that police officer and what they see on the video. But so we're not going to get into the facts.
So you're saying about my pride, I've done already convicted of pride and did my time on it, so I owe my pride, I expect what I got
because that's what the law is in the state of Texas. If you continue to break the law, then your punishment gets worse. Yeah, if you're found guilty and you have a felony conviction, then your punishment gets worse every time. So in this case, it goes from a second-degree felony to a first-degree felony. It bumps it up one. Do you understand that? So if you're found guilty in either of these cases, because you have that prior offense, the punishment is actually 5 years minimum up to the rest of your life in prison. Do you understand that? And not the 2 to 20. You understand? Answer yes or no, please. Okay. And so do you want, and what was the offer that was made?
It was to plead to the assault on a public servant for 5 years and dismiss the burglary.
So Mr. Rojas has gone over with you that the state's made an offer if you wanted to enter a plea of guilty for a 5-year term in prison on the assault on a peace officer with a dismissal on the burglary of a habitation. You have every right to reject that and let a jury decide on both of these. I just want to make sure you understand what the possible consequences could be if you go to trial and what your options are right now if you wanted to enter a plea. And do you understand all of that? And do you want to reject that and have your case go to a jury, both cases? You want to take that 5 years? All right, I'm going to hold the case while now you're going to have to go over that paperwork and sign it on the tablet with Mr. Rojas, right? Okay. All right, ma'am, you're Veronica Sanders again. And we have already gone through, I've taken judicial notice of the court's files with the finding that Ms. Sanders is competent. Mr. Rojas, will your client waive the formal reading of the indictment?
She will.
Ms. Sanders, Sanders, and cause number, and we're going on count one only in that
Yes.
one. Ms. Sanders, the state has elected to proceed on count one only in cause number 23, DCCR 1114. You're charged with a second-degree felony offense of assault on a peace officer or judge from July 18th of 2023. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
Mr. Rojas, will your client waive the formal reading of the indictment?
She will, Your Honor.
Ms. Sanders, and cause number, and we're going on count one only in that
Yes.
one. Ms. Sanders, the state has elected to proceed on count one only in cause number 23, DCCR 1114. You're charged with a second-degree felony offense of assault on a peace officer or judge from July 18th of 2023. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
All right, Ms. Sanders, I'm going to find, again, that you entered your plea of, find that you're mentally competent, find that you entered your plea freely and voluntarily, find sufficient evidence at this time to find you guilty, and find you guilty of the second-degree felony offense of assault on a peace officer. Sentence you in accordance with your agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I will sign a dismissal as part of that agreement in cause number 23, DCCR 1005. I've handed you the trial court certification that shows that this was an agreement that I followed, and so you have waived any right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long it lasts, you can talk to Mr. Rojas. All right, good luck to you, ma'am. You can go back with the bailiff.
Thank you, Your Honor.
Yes, sir.
The courtroom session opened with the judge greeting Veronica Sanders before officially recognizing the court records as part of the case. The judge explained that a competency evaluation completed by a medical expert on September 17, 2023, concluded that Sanders was mentally fit to face trial. After asking both attorneys if they had any additional evidence about her competency and hearing that there was nothing more to present, the judge ruled that Sanders was legally competent to continue with the proceedings. The prosecutor then informed the court that after speaking with Sanders, she had decided to enter guilty pleas in the pending cases instead of moving forward with a trial, even though she chose not to sign the related paperwork. The judge then reviewed the first criminal charge and explained that case number 23 DCCR 105 involved a second-degree felony burglary of a habitation connected to events from July 19, 2023. The court carefully outlined that a conviction at trial could result in a prison sentence ranging from 2 years to 20 years and made sure Sanders understood the possible consequences before continuing. The judge then moved to the next file and stated that case number 23 DCCR 1114 involved a second-degree felony charge for assault on a peace officer tied to an incident from July 18, 2023. The court continued reading each allegation into the record to ensure every charge and every possible legal consequence was clearly explained before the hearing moved to the next stage. The judge continued by explaining that the indictment also stated Veronica Sanders had a previous conviction for assault on a public servant that was entered on March 24, 2021. The court said that this earlier conviction could increase the seriousness of the current charge if the prosecution properly presented the required notice. Instead of being sentenced under the range for a second-degree felony, the case could be elevated to a first-degree felony because of the prior conviction. The judge carefully explained that such an enhancement would raise the possible punishment to a minimum of 5 years in prison with a maximum sentence of 99 years or even life imprisonment. The court then asked Sanders if she understood the legal consequences and requested a clear answer. Sanders admitted she was feeling nervous and said she wanted the case to go to trial because she had recently watched the video evidence. She stated that the recording did not appear to show her attacking the police officer as described in the charge. Before she could continue explaining her point, the judge stepped in and asked her to pause so the courtroom could address the matter in an orderly way before moving forward with the discussion. The judge asked Sanders to pause and explained that the courtroom would not discuss the detailed evidence during this hearing because that was the purpose of a future trial. The court noted that her attorney had likely already explained the process and reminded her that the officer involved would testify before the jury along with any available video recordings. The judge said that if Sanders denied the allegations, then it would be the jury that would examine the testimony and the video before deciding what they believed happened. The court made it clear that this hearing was only for explaining the legal process and not for debating the facts of the case. Sanders then spoke about her previous conviction and said she had already accepted responsibility and completed her sentence for that matter. The judge acknowledged her statement, but explained that under Texas law, a prior felony conviction can increase the punishment for later felony offenses if another conviction is returned. The court emphasized that the law allows penalties to become more severe for repeat felony convictions, and that this was why the current charge could be raised from a second-degree felony to a first-degree felony. The judge again reminded Sanders that if she were found guilty, the possible sentence would begin at 5 years in prison and could extend to the rest of her life before asking once more if she fully understood the serious consequences. The judge reminded Sanders that because of the possible sentence enhancement, the punishment was no longer limited to 2 years through 20 years and asked her to answer clearly that she understood. The court then turned to the plea offer and asked the prosecutor to place the agreement on the record. The prosecutor explained that the offer required Sanders to plead guilty to the charge involving assault on a peace officer in exchange for a 5-year prison sentence, while the burglary charge would be dismissed. The judge carefully reviewed the proposal and made sure Sanders understood that she had the full legal right to reject the agreement and instead allow a jury to hear both cases. The court explained that choosing a trial could lead to much more serious penalties if a guilty verdict was returned and wanted to be certain she understood every possible outcome before making her decision. After hearing the explanation, Sanders decided to accept the 5-year plea agreement rather than proceed to trial. The judge then paused the hearing so she could review the required documents with her attorney and complete the electronic signature process before the case continued. Once the paperwork was ready, the hearing resumed with the judge once again confirming Sanders' identity and placing the earlier competency finding into the official record. The court then asked whether Sanders would waive the formal reading of the indictment, and her attorney confirmed that she would before stating that the proceedings would continue only on the first count of the remaining case. The judge announced that the prosecution had chosen to move forward only on the first count in case number 23 DCCR 1114, which involved a second-degree felony charge of assault on a peace officer connected to events from July 18, 2023. The court then asked Sanders how she wished to plead and confirmed that her guilty plea was being made freely and by her own choice. The judge also asked if she was admitting guilt because she accepted responsibility for the conduct described in the charge. The court next referred to the signed legal documents that had been marked as State Exhibit 1 and asked whether Sanders had carefully reviewed every page with her attorney before signing them. The The judge confirmed that she understood everything contained in the paperwork and reminded her that accepting the negotiated plea agreement would also mean giving up the right to file an appeal if the court followed the agreed sentence. The court further explained that anyone who is not a United States citizen could face serious immigration consequences after entering a guilty plea, including removal from the country, denial of future admission, or refusal of citizenship under federal law. The prosecution then formally offered State Exhibit 1 into evidence, and the defense raised no objection. As the hearing continued, the judge repeated the same important legal advisements to ensure the official record was complete and once again confirmed that Sanders understood the charge, the plea agreement, the signed documents, and every legal consequence connected to her decision before the case moved toward final sentencing.